Hi, I'm Steve Luxenberg, and I've been invited to talk about my book, Separate, the story of Plessy V Ferguson and America's journey from slavery to segregation. And pleased to be here. I love libraries since they house our books and give people a chance to read them.
Yes, library owns your book, and I would recommend it to everybody. It's an amazingly accessible and fun read. I mean, for the topic, it's not fun, but it's very well written. So I guess we could start with what brought you to the topic, and why did you write the book?
Well, I'd like to tell you that it was not at all about ego, but of course, authors have to have an idea that they have a story to tell. And I had written the first book, and I decided that I had a second book in mind. And I looked around at various genres like biography, quickly decided that biography was not my favorite topic because you're sort of bound by the beginning and end of a life and not the beginning and end of a story. And so instead I gravitated to the story of race in the 19th century and the roots of racial segregation, which is largely the framework for the book, because I felt that I didn't really understand the roots of our racial discord today. And in order to understand that, I needed to go back into the 19th century. I was surprised to find that we should talk about not just the civil rights movement of the 1950s and 60s, we should also talk about the civil rights movements of the 19th century, because there were laws passed after the Civil War that were remarkably similar to the Civil Rights Act of 1964. I found that, I think that there's a misconception that we people today talk about race better than people in the 19th century, but there was a very lively discussion about race back then. And the Civil War, of course, was fought over race. And I felt that by telling the entire sweep of the story through the framework of public accommodations and transportation, which is the issue at root in the Plessy versus Ferguson ruling of 1896, that it was a way to understand our own discussions about race today.
Yeah, and that theme definitely comes through in the book. So that's fantastic. I guess we could start with what was the Plessy versus Ferguson. And I think the popular knowledge is it's the beginning of separate but equal. But what was the case actually about? And then we'll talk about how it came about.
Recently there have been a number of Supreme Court oral arguments in which Plessy has come up. Justices Alito and Kavanaugh have both cited it, as has Thomas. And on the liberal side of the court, it's come up in another way. One of those arguments was in the abortion rights case that is being debated out of Mississippi. I think the justices need a briefing on what Plessy actually says, because what they imply about it is incorrect. That is, they imply that the court in the 1954 Brown versus Board of Education decision overturned Plessy because, quote, it was egregiously wrong. Those words, egregiously wrong, were used several times recently in arguments. The court did not overturn Plessy because it was egregiously wrong. It overturned it, it said, in 1954, because it had found new evidence that showed that separate was inherently unequal. And that's the important point here, is that the court doesn't like to overturn itself. It much prefers finding a different avenue, which is what it often does and did in Brown. Brown was, of course, about education. Plessy was about transportation. That is specifically a Louisiana law that required, under criminal penalty, that the railroad run separate cars for white and black passengers. They must be equal, the law said. But of course, it was only enforced to eject people of color from the white car. It was rarely enforced in the other way. And there was a group of mixed race they called themselves Creoles of color in the 1890s. The law was passed in 1890, who wanted to overturn this law, and they banded themselves together. They called themselves, they needed a public relations agent to get them a better name, but they called themselves the Committee to Test the Constitutionality of the Separate Car Act. A mouthful. But they arranged for a volunteer, in fact, two volunteers, Plessy was the second, to ride the railroad to get themselves arrested. The railroad was aware of what they were doing, and to initiate, therefore, an arrest that would trigger a challenge. Frequently today, I read I'm a journalist, I work at the Washington Post, I'm an associate editor, I frequently read my journalistic brethren making the mistake of saying that the Plessy case was an appeal of his conviction. It was not. Otherwise, it would have been called Louisiana v. Plessy. It's called Plessy v. Ferguson because Ferguson was the judge. He had decided to rule on the constitutionality of the act before holding a trial on the charge. Plessy's lawyers then could take an appeal of his ruling rather than trying to appeal a conviction. This was an important gift that Ferguson gave to them, because had Plessy been convicted, they were planning what's called a habeas corpus case, which means in Latin to release the body, the corpus, from the jail. That would have meant Plessy would need to be in jail. And as we know, Supreme Court cases do not occur overnight. This one ran from 1893 to 1896 in the number of years that it took for the case to be decided. You don't want Plessy sitting in jail for 3 years on the charge of sitting in the wrong railroad car. So they were delighted to have Ferguson rule against them, essentially, by ruling on the constitutionality of the act. So that's what went to the Louisiana Supreme Court. They ruled that the act was constitutional, as Ferguson had done. And that's the appeal that went to the Supreme Court, and took a long time before the court got around to ruling on it. The court had no urgency about civil rights cases. And the expected ruling was just what happened. No one thought the court would overturn the Louisiana law. The court had ruled against civil rights plaintiffs repeatedly from the end of the Civil War through the 1890s. The other important thing to know is that when the ruling was released, no one called it the case that established a doctrine of separate but equal. There's no doctrine in the ruling. There is not even the mention of the words separate but equal. That it's mentioned in the dissent, but that idea that it was a doctrine and that phrase separate but equal is the result of years of the Supreme Court using Plessy as a precedent in other cases, so that by the time that Thurgood Marshall, the justice who was the lawyer when he was a lawyer, brought the Brown case, he and the NAACP legal defense team, they were aiming at Plessy because that was the case that had become the most important. But nobody thought it was all that important in the 1890s.
Yeah, that's that I was surprised to learn that at the end of the book, that it just kind of became this, just another ruling, and only mentioned in like footnotes in people's obituaries. But I would like to talk a little bit more about the two gentlemen that the book kind of you kind of focus on the most, and I'm going to murder his last name, but it's Tourgée. Is that how he would say it?
Yes, Tourgée. Sort of a Z sound there.
Yeah.
For readers, I do have the pronunciation when we first meet him in the book.
Yeah.
He put an accent over the E in his name as an affectation later on in his life, but he wasn't born with the accent. He was born in Ohio, as it happens, in the Western Reserve, which, for those of you who've wondered where the university's name, Case Western Reserve, comes from, that Western Reserve was originally a territory that was part of the state of Connecticut in the days when the country was young. And the Western Reserve was a progressive stronghold. In Ohio, it became a political issue because the counties along the southern border on the Ohio River, close to the line between the North and the South, and therefore the first place that a runaway slave would end up. They didn't agree with the abolitionists of the Western Reserve. They thought life was a little more difficult down south. And so that in the Ohio legislature, you'd frequently get this divide between the southern bordering counties of Kentucky, along the Kentucky border, and the North Western Reserve. Anyway, Tourgée was born and lived primarily in Kingsville, to the east of Cleveland, and he served twice in the Civil War. And the Civil War was a formative period in his life. He was not very political before the Civil War, and afterwards he was a raging radical. In fact, when he was young and he was courting his wife, the woman he ended up marrying, Emma, he told her that she was much more political than he was. He called her a rabid Republican. Republican being the party of anti-slavery in those days. He went on to live in the South with his wife in North Carolina for nearly 20 years. No, I'm sorry, that's not right, 15 years. And when he left, the North Carolinians celebrated because they thought he was a thorn in their side. But he wrote a series of best-selling novels as a result of his experience in what was called the Reconstruction era, living in North Carolina. And that was his claim to fame more than his lawyering. He wasn't a Supreme Court lawyer. He went on to become a very widely read newspaper columnist, working for a newspaper that no longer exists called the Chicago Inter-Ocean, which is the idea of the newspaper was it was going to join the two coasts, and it was between the oceans. It was very well read at the time. It did publish for a number of years, 40 years or so. And Tourgée was contacted by this committee that I mentioned down in New Orleans, the committee of testing the Separate Car Act, for his advice. And one thing led to the other, and he offered his services, and they liked the offer because he was offering to represent them for free. And so a partnership was born, but Tourgée never went to New Orleans during the time of representing the committee. He went to Washington to argue the case in April of 1896 at the Supreme Court, but he never met his co-counsel, James Walker from New Orleans, because Walker didn't go to Washington. He was not feeling well. So everything was done long distance, which in those days, of course, meant letters, not phone calls, or letters and telegrams, not phone calls or cell phones. Fortunately, because of the letters between Tourgée and the head of the committee, Louis Martinet, that correspondence survives in Tourgée's archives, which is in Chautauqua County, New York, which is where he ended up living after he left North Carolina. And you can read the entire strategy of the case as recorded in that correspondence, because that's how they talked about what they were going to do, since they had no other way of communicating other than telegram.
Well, and that leads me to my next question, which was, what was his, he had a very novel, I guess, radical argument for the case. And I'm thinking mostly about this idea of what determines Blackness. And
well, think about this from a lawyer's point of view. You're going to the Supreme Court. It's the 1890s. You know that the court is not sympathetic to civil rights. You know that you're probably going to lose. What's your argument? What are you going to say to them? You're not going to try to go over the same ground that the court has already ruled on. So Tourgée was always looking for the new argument. And he had a lot of them. I once interviewed a judge on stage, and I told him what Tourgée's approach was, which was a kind of kitchen sink approach. And this judge, who had been an appellate judge, said, that's not the right approach. Appellate judges don't like kitchen sinks. But he was looking for a new argument. And there was a very compelling one, an obvious one, which is that the laws, and there are not that many of them yet in the South, that required separation. So I use the word separation rather than segregation because that was the word that they used at the time. But these laws requiring separation built on each other. And the first few did not make it criminal. It did not criminalize the passenger's behavior. It criminalized the railroad's behavior. The railroads were required to run the separate cars under penalty of a fine, or obviously can't put a company in jail. Louisiana was the first state to criminalize the passenger's behavior. So that was the argument that gave Tourgée the grounds for his argument, which was, in order to usually bring a criminal charge, you need testimony, you need witnesses, you need to have due process under the 14th Amendment. Where's the due process when a conductor who isn't a legal officer walking down the aisle of a train decides that you, Homer Plessy, who looked white, was probably, not to use percentages, but it's relevant here, probably about 1/4. They said he was 1/8 in their briefs, but they didn't really know. He was probably about 1/4 black. He had never been a slave. His parents had never been enslaved. His grandparents hadn't been enslaved. You got to go back to his great-grandmother before the American takeover in 1803 of New Orleans and Louisiana to find somebody who had been enslaved. That's often a misconception about Plessy. You have to. So here he has a volunteer who has gotten arrested, and under criminal penalty, where is the justice in this? Is what he was basically asking. And so he felt that it applied under the 14th Amendment. Now, the 14th Amendment has many clauses, but one of them is due process, meaning that you have to have some sort of hearing, testimony, witnesses. And the other is equal protection under the law. Now, it doesn't say that, what it says is states cannot pass legislation that is unequal, essentially. Here we have an individual, but it is a state law, so it seems to apply very well. Tourgée's other argument, the one that you mentioned, was that normally, in order to have a legal concept come into play, you have to have definitions. So what is the definition of the law for white, and I'm quoting the act now, this is not my language. The Louisiana Act said that white and colored passengers needed to have separate cars. Well, what is colored? What is that, especially in Louisiana, Tourgée said, what does it mean to be colored since you have so many mixed race people? Other states, North Carolina, Michigan, Georgia, had percentages for what it meant to be colored, and they were different percentages. So in Michigan, you could be considered white if you were 1/4. In North Carolina, you had to be, Michigan was 1/16. I think North Carolina was 1/4. I forget the percentages. For those of you, read my book. That's where it's correct. But he said there is no definition in Louisiana law. Louisiana has never made a definition. So the conductor has no rules, has no yardstick by which to make his decision. And how does he know without doing an investigation? So that was one of their main arguments. The Supreme Court didn't buy this argument. I think you were going to go to a couple of other names. So the Supreme Court ruling was 7-1 against Plessy. One justice did not participate. The majority opinion was written by a man named Henry Billings Brown, who was born in Massachusetts and went to Detroit, Michigan, to practice law, and that's where he lived for most of his adult life. The only dissenting judge was one of the two Southerners on the court in 1896, a man by the name of John Marshall Harlan. Harlan was a Kentuckian, and he had been the lone dissenter, or in some cases, there was one other dissenter, in many of the Supreme Court decisions since since he got on the court in 1877. So Harlan was the only expected vote that Tourgée and his team could count on. There is one letter where they go through the rest of the justices, not by name, to try to come up with a 5-4 win, and they really can't get there. But it's interesting reading how he tries to fool himself or persuade himself, Tourgée, that he can get a win out of this. Now, it's important, I think, for readers to know, for listeners to know, that this is not your Supreme Court of today. In the 1890s, there was no 5-4 split. When I hear the Supreme Court mentioned today, I automatically think, until recently, 5-4, now 6-3, who's going to be changing sides in order to get to a different conclusion. In the 1890s, 90%, I'm going to repeat that, 90% of the cases were decided unanimously. Occasionally, there was a 5-4 case, but there were many term meaning the term of the court from October to May or October to June, where there were no 5-4 decisions. So, it's not like Tourgée had a 5-4 court to work with and he was trying to persuade one justice to change sides. He was looking to change 2 or 3 or 4 people's minds, and he knew that was impossible. In fact, in 1893, in a letter to Martinet, he suggested that they withdraw the case because they were going to lose. That letter, is the only evidence that they thought about it. There's no letter from Martinet saying we should do this. My conclusion as a historian is, look, they're fighters, they're protesters, they're committed to a cause. They don't back off. And so they continue with the case until its conclusion, which of course they lose.
Well, maybe we could talk a little bit more about why they lost and what the argument that Brown wrote, because it seems to be something that is often misunderstood, I guess.
Well, so, Supreme Court cases have to be rooted in the Constitution. Tourgée's argument, Tourgée and Walker and his co-counsel Carter Phillips in Washington, they rooted their arguments in both the 13th and 14th Amendments. Now, a little background here. The 13th, 14th, and 15th Amendments are often bound together and called the Civil Rights Amendments because they all take place in the late 1860s after the Civil War. And they do 3 different things. The First Amendment, which was actually passed by Congress, but later ratified by the states while Lincoln was still alive. If you saw the movie Lincoln, the Spielberg movie, that the action is around the 13th Amendment. That's the amendment that abolishes slavery. It passed in January of 1865, went to the states, and then was finally ratified after Lincoln's death. The 14th Amendment does something that the senators at the time understood was necessary, which was to confer citizenship on the people who had just been freed, because the Dred Scott decision raised a doubt about their citizenship. So the 14th Amendment, first of all, confers citizenships on anybody born in the United States. It also, though, establishes equal protection and due process. The 15th Amendment, which is passed last, is the amendment that provides voting rights for people of color, but of course not for not for women, just for men. Although the amendment itself doesn't say anything about gender, but it was widely understood that it didn't include women. And so we have the 19th Amendment that confers voting rights for women. Those 3 amendments are the basis for the first civil rights cases, really. I mean, the Dred Scott case is about rights, but it's really about whether somebody is a slave or not. It's not about the rights of people who are free, because they weren't, people who were enslaved weren't free. So an entirely new era of the law is born as a result of those three amendments. But the Supreme Court began in the 1870s to narrow their interpretation of the 14th Amendment. They did not apply it to individuals or to businesses. The amendment itself said states cannot pass laws that restrict rights, so that's the way they interpreted it. And by the 1890s, when states began to pass laws requiring separation, that was another stage in the development of civil rights law. Brown, Henry Billings Brown. Now, let me say something about the court. The court at this point was changing, but it was still dominated by Republicans. Republicans, remember, are the party of anti-slavery. The party itself is changing in the 1890s, but you would think that you would have a sympathetic court as a result of the Republican string of presidents between Lincoln and Grover Cleveland. They were all Republicans. But the court was not sympathetic because the court was basically following the lead of the country, not leading the country. And Brown rejected for the majority. He writes the decision, but remember, it is 7 justices. They reject the argument that Louisiana law violates the 13th and 14th Amendments. And instead, they rule, and this ruling is quite narrow, they say, under what's called the police powers of a state. Now, the police powers is a legal term of art that means the power to keep law and order. That's where police powers come from. But under the police powers of the state of Louisiana's legislature has the authority to pass such legislation. And yes, it must be, equal as well as separate. So when people today describe it as establishing a doctrine or ruling about its constitutionality, that was not the thrust of the decision. The thrust of the decision was Louisiana has this authority. Now, why do I make this point? I make it because I feel as if people blame the Supreme Court for separation. If the Supreme Court hadn't ruled that way in Plessy, we wouldn't have had a whole era of Jim Crow. Well, first of all, Jim Crow begins in the 1840s on railroad trains in the North where there are free blacks. So what the Supreme Court is doing in 1890 is essentially affirming a custom that had been going on for 50 years. And secondly, other state legislatures, mostly in the South, had to pass similar legislation in order for separation to start to spread not only on railroad trains, but to schools and to public accommodations and to hotels and restaurants and the entire era of Jim Crow. As I've written in several op-eds, to lay the blame at the feet of the Supreme Court is to remove ourselves for it isn't the shame of the court, it's the shame of the North, it's the shame of the South, it's the shame of the country that we had an entire era of Jim Crow legislation, because it required all of those legislatures and all of those representatives to take that action. That's my view. And I don't want to let the Supreme Court off the hook. The Supreme Court could have stopped this. It did not, but it didn't create it. And it had to come along with other people's actions as well.
And then Justice Harlan's dissent, he was known as the dissenter, as you kind of alluded to. He's the one who's always kind of against the majority. If there was a dissent, it was usually him.
He acquired the nickname, the Great Dissenter.
Yeah.
Harlan was a fascinating guy because digging into his past, into his background. So he was born into a slaveholder's family. It was not a large plantation with a huge workforce of enslaved people, but they were household slaves. And he ran for Congress as a young man in his 20s in 1859, before the Civil War, on a pro-slavery platform. This was not a man who was arguing against slavery from a young age. But when the Civil War broke out, he was in that category of Southerner that believed that the Union needed to be preserved, even if he could not fight a war to end slavery. He said in a letter to the Louisville paper, how many people write letters telling you why they're going into a war? But he wrote a letter saying that if this becomes a war to end slavery, then I will no longer be able to fight for the Union. Now that didn't happen, in part because he left the Union Army early because his father died and needed to go home to tend to business matters. When he got home, he ran for Attorney General, which a position his father had held. He was born into a political family, and he was a politician first and a justice later. Now, he loved being on the Supreme Court, and I think it was his calling, but he didn't see the Supreme Court as his ambition to begin with. In Kentucky, in the 1850s and in the 1860s, being a anti-slavery or being a Republican after the Civil War was like signing your death warrant politically. He couldn't get elected. And in fact, he ran as the Republican candidate for governor in 1871 and 1875, and he lost both races. So his political career in Kentucky was kind of at a dead end, which is why he turned his eyes toward the Supreme Court. And he kind of campaigned to get on the court. And Hayes, who was also from Ohio, Hayes appointed him in 1877. Harlan had a conversion, and I think that conversion is very much a real conversion. People have asked, well, where does it come from? Well, it doesn't come from one thing, but it comes from fighting on the Union side. It comes from acquiring a law partner in 1868-69 named Benjamin Bristow. Bristow, whose name is forgotten today, but was a very prominent politician, was also from Kentucky. He went on to become Secretary of the Treasury, the first Solicitor General of the United States. He ran for president, didn't get the nomination. He and Harlan were great friends, and then they were rivals, and then they had a falling out. But Bristow was to Harlan's left. Bristow, as a U.S. attorney for Kentucky in 1867, prosecuted some of the first cases under the civil rights style acts that were being enacted after the Civil War. So you have the Bristow influence. And then, once you become a Republican, and the Republican Party is the party that is pushing forth civil rights legislation as much as anything is being pushed, you kind of can't be half-hearted about it. So by 1873, 74, Harlan is a Republican activist. He manages Bristow's campaign at the 1876 Republican convention. You can't. There isn't any room for somebody who is opposed to civil rights at that point. So Harlan, I think, throws himself into it. And as he runs for governor, he says, in response to his opponents' accusations of hypocrisy, that you used to be pro-slavery, you used to be this. He said, yes, and I was wrong. I'd rather be right than be wrong, essentially, is what he said. And so I think that by the time he gets on the court, he's a different man. Now, his real conversion, I think, takes place in 1882, 83, when the court needs to rule on the constitutionality of the Civil Rights Act of 1875, which is a broad act that gave equal accommodations to Black and white throughout American life. And the court overturns that law. Harlan is the dissenter. Now, he's going to be the only dissenter. He knows that because the court has made this decision in private. They're writing their opinions. And he is very much, he's very nervous, according to his wife, who wrote a memoir about him later on. He's very nervous about this opinion because it's going to be the first time that he stakes out this dissenting position. And he doesn't seem to be able to write it. He dawdles. It's 1882 becomes 1883. He still hasn't written it. The court is saying, look, we have to release this ruling by the by the end of the term, which is June or May or June of 1883, he still hasn't written his opinion. In October, at the beginning of the new term, the court releases their majority opinion, and Harlan says from the bench, "I'm writing a dissent, but I haven't finished it." Now think about that. That's unusual, right? I mean, that's extraordinary. Now he does finish it quite soon after that, and there's a wonderful story about what apparently relieves his writer's block, which you can read in my book. But when his opinion comes out, now think about this. The majority opinion is what is, is the finality of the ruling, but it's Harlan's dissent that is published widely in newspapers. It runs an entire newspaper page. That's how long it is. And many newspapers carried the entire dissent, not because they agreed with it, because it was so extraordinary. Later on, in a Mississippi case in 1890, he writes a dissent. Nobody carries the dissent. When he releases his Plessy dissent, which is what makes him famous today, nobody carries his Plessy dissent. It's his 1883 dissent that is the key decision. Now, why don't we know more about this 1883 case? And the answer is because it overruled the 1875 Civil Rights Act. It didn't affirm the constitutionality of something in Louisiana. So rejecting something doesn't get you as much attention as affirming something when it comes to the Supreme Court.
Right.
I hope that's a good explanation.
That is an excellent, that is, yes.
It's complicated, but remember, these are human beings.
Mhm.
These are not just lawyers, and this isn't just legal concept. These are real people trying to make real decisions. And Harlan had a lot of pressure on him. It can't have been easy. You think about this, from 1883, when he writes that dissent, until his death in 1911, but all the way through the Plessy era, for him to be the only dissenter most of the time. So you're sitting in a room, think about this, you're sitting in a room, there are 9 people there, and you're always going to be the dissenter, and you've got to defend your position. It would have been easy for him to go along. Remember, this is a court that 90% of its decisions are unanimous. Now, of course, they're not always focused on civil rights. We are in talking about this. They got a lot of other cases, and a lot of them are very mundane, and that's why they're unanimous. The court didn't have, it wasn't until the 1890s that the court had a court of appeals structure below it that they could, the cases would end before they got to the Supreme Court. But I find it fascinating. And remember, this is a court. The other thing to say about the court is, this is not the Supreme Court of today, as I've said twice. There were no women. There were hardly any people of diverse backgrounds. They were Republican and Democrat, but they were all from the same social class. They were all from the same economic class for the most part. They looked at the world very much the same way. And almost to a person, they cared more about property rights than they cared about civil rights. And they also thought that civil rights wasn't a federal matter. Now, today we understand that there are some things that are national, but in the 19th century, they did not see it that way. Some people don't know that there's a 10th Amendment that says all rights not expressly given to Congress are reserved to the states. And there were many cases decided on those grounds, and still are, in the 19th century. Some people considered themselves to be citizens of their states first, and citizens of the United States second. Now, why would that be? One reason is that you're living in the South, let's say. I'm going to do it both ways. You're living in the South. Slavery is your economic system. The North doesn't have slavery. The North has a lot of people who think there shouldn't be any slavery. They have some people calling themselves abolitionists. Well, what do you say? I say, I'm from Georgia. I'm from Georgia. I don't care about what those Northerners think. Similarly, you're in the North, in Ohio. I don't care about slavery. That's not my system. Those are all those people down South. So you can see why states, there's a tension in the Constitution, which still exists today. And that tension is, It doesn't work if it's a federal constitution only, and it doesn't work if it's a state, it's a compact of states constitution only. Both things are there, and that's a fragile balance. And so you'll see that when activists can't get the Supreme Court to go their way, they start going to state legislatures. That's what's happening now with voting rights. The Republicans are going to state legislatures to get voting rights laws enacted. When the states are against you, the South has segregation. Where do you go? You go to the Supreme Court. That's what happened in 1954. The Supreme Court finally went in that direction. So that there's a constant tension in the that the Constitution not only embraces but allows to make.
I lost your audio here. Hang on.
Okay.
All right, sorry. The last thing I heard was when the states are against you, you go to the Supreme Court.
Right. So there's a constant tension that exists in the Constitution, and it both makes the country work and it creates conflict.
That's interesting. And right before when you were talking about these are individual men, and you were talking about Harlan, thinking about that, one of the things I really appreciated about your book was you included the wives. And obviously there's a rich source material with letters and diaries and things. But it was interesting to read about how the families fared while these guys were off
Well,
careers.
I'm not just being generous here. The wives were very important to in these particular marriages. Tourgée needed to earn income, and his wife was constantly telling him, "Don't go doing that Civil Rights Act stuff. Right? We need money." But he relied on her. He relied on her for years, going back to their courtship in Ohio. Harlan's wife, Malvina, whose name was, she was known as Mally, was also very important to him. Often his first move was to write something to Mally to tell her what was going on. Now, there aren't as many letters with Mally as there are between Tourgée and Emma, in part because they were living in the same place, and Tourgée was often traveling, and so there was more of that. But it wasn't hard for me to include them. It does make the book a little different than other histories.
Yeah, and it definitely is. It works really well, and it's a nice addition, and it does add to the narrative amazingly well, and it fleshes out the story.
Think about slavery. Slavery is very intimate in its own way, right? Slaves they're not separated from their masters, which is why you didn't have separation on trains in the South before the Civil War. I mean, who would put their enslaved servants, someplace else? That intimacy that existed, I felt that the book needed to be intimate. You needed to have the interior lives of these actors, and I wish that some of them had been women, the main characters, but they're not. But there's two other characters in the book who I think are important. One of them is a person, the other one is a place. The person is Louis Martinet and all of those resistors of the 19th century. And I try to chronicle the resistance that occurred, because there were resistors to separation going back to the 1840s. Frederick Douglass was one of the first resistors on a Massachusetts train. Frederick Douglass, I call him the most famous Black man in America in the, by the time he reaches the prime of his life. The other character is a place, which is New Orleans. New Orleans is, is an unusual place today, but it was always unusual. And I don't think that the case could have come out of any other city than New Orleans, because you had this educated, wealthier, well-established group of mixed race people that didn't exist yet in the other southern cities. And so they were able to carry forth with a challenge. They raised money. They had an established political place in the community. That was unusual back then.